Hello, and so this episode of the Diary of a Lawyer, and I want to cover the most recent decision by the U.S. Supreme, not just of affirmative action, but also other decisions on, for example, the rights of the LGBTQ, the student loan program that Biden instituted to provide debt relief for students, college students, struck huge cost college. We have to remember also that around this time last year, Supreme Court also overturned Roe v. Wade, which is concerned with the woman's right to choose, its abortion, voting rights, trans rights, and so on and so forth. And since then, the court has suffered a crisis of legitimacy, including specific impartiality or association with conservative donors and taking gifts, alleged gifts, and it has since been described as a court gone rogue. And that very question was put to President Biden, and he is reported to have said, "This is not a normal court." And that is where we start. And so, what is the issue in terms of the court's flurry of decisions last year and this year? There is a majority of around 69, sorry, 63, six being conservative, three being liberal. Since then, many of the decisions that have been the bedrock of a sense of justice and equality and creating justice, historical justice around race and minority rights have been overturned. And so, what is the position as things stand? So, the Supreme Court says that colleges and universities can no longer take race into consideration as a specific basis for granting admission, which is a landmark decision overturning long-standing precedent that has benefited Black and Latino students in higher education. Chief Justice Roberts wrote the opinion for the conservative majority, which is hundreds of pages long, saying that Harvard and University of North Carolina violated the equal protection clause with measurable objectives to justify the use of race. They say the programs of stereotyping had no specific end point. He says the Harvard and UNC admissions programs cannot be reconciled with the guarantees of the protection clause. Both programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. We have never permitted admissions program to work in that way and will not do so today. It's wrote. The majority opinion claims that the court was not expressly overturning prior cases authorizing race-based affirmative action and suggested that how race has affected an applicant's life can still be part of how their application is considered. Even if the court did not only end race-based affirmative action in higher education, its analysis would make it practically impossible for colleges and universities to take race into account, as the three Democratic committees stressed in dissent. In a lengthy concurrence, Justice Clarence Thomas, the second black person to join the Supreme Court, spoke in unusual personal terms as he criticized the use of affirmative action policies by colleges universities, which he described as pattern-based preferences designed to ensure particular pressure makes in their classes, while I'm paying for social factors which have befallen my race and all self-discrimination. I hold out enduring hope that this country will live up to its principles so clearly enunciated in the Declaration of Independence and the Constitution of the United States. All men are equal, are equal citizens, must be treated equally for the law. Thomas Ford. Justice Sonia Sotomayor, joined by Justice Elena Kagan and Ketanji Brown Jackson, issued a fair dissent, saying the opinion rolls back decades of precedent and momentous progress. The result of today's decision is that the past can follow by assessing individualized suspicion. They cannot play a role in assessing a person's individualized suspicion to a vast learning of that indefensible rating decision is not grounded in law and subverts the 14th Amendment's guarantee of protection. In a demonstration of the controversial nature of the case, justices read their dissents from the bench for the first time since 2019. The devastating impact of this decision cannot be overstated, Sotomayor said while reading a synopsis from the bench. In ending her dissent, Sotomayor quoted Dr. Martin Luther King, attempting to end the opinion on a pessimistic note. As has been the case before in the history of American democracy, the arc of the moral has been bent towards racial justice, despite the court impede its progress, she said. Sotomayor pointedly did not use the passive power. I respectfully dissent. In our own dissent, Jackson, the only black woman on the bench, accused the majority of having let them eat cake of obliviousness in how the ruling on Alabama violated fear, but deeming race relevant in law does not make it so in life, she said, joined by the court's two papers. Jackson wrote that the majority had detached itself from this country's actual past and present experiences. No one benefits from ignorance, she added. However, the ruling appears to exempt military service academies. The ruling says that the U.S. military service academies can continue to take race into consideration as a factor in admissions. In the majority opinion, Roberts said that the cases before the court did not address the issue and left open the possibility that there are potentially distinct interests that military academies may present in a future case. During oral arguments, Solicitor General Elizabeth Prelogar stressed the unique interests of the military and that race-based admission programs other nations compelling interest in diversity. Jackson called out the caveat and dissent. The court has come to rest on the bottom line conclusion that racial diversity in our education is only worth potentially preserving so far as it might be needed to prepare Black Americans and other underrepresented success in the bank or the bedroom, the boardroom, so a particularly awkward place to land in light the history of the majority wants to ignore, Jackson wrote. The GOP celebrated whilst the Democrats blasted the court. So there's no, understandably, that would be the outcome, but according to observers such as CNN legal analysts, the legal fights will continue. And she says that this opinion, make no mistake about it, is going to change the landscape of education. And this is what majority has asked for. Other observers note that in those states that have already banned racial preferences and gone after diversity statements and other softer uses of race in admissions, the decision is going to make it virtually impossible for colleges and universities to take race into account in any specific admissions decision. But in states that continue to permit colleges to take race into account, we will surely see efforts to encourage kinds of uses the majority does not expressly disavow, whether diversity statements and litigation challenging those efforts as being inconsistent with the spirit of the decision. Now, challenges in the case targeted Harvard and the University of North Carolina, arguing that their programs violate the protection principles and dash the promise of a colorblind society and discriminate against Asian Americans. They asked the court to overturn precedent and insist that higher education should explore and not further develop race neutral alternatives to achieve diversity. They argued that the policies violated Section 6, Title 6 of the 1964 Civil Rights Act that prohibits schools receiving federal funds from discriminating based on race as well. The lawyers also argued that the UNC violated the 15th Amendment's guarantee of equal protection under law, which covers state universities. Lower US courts had ruled in favor of the schools, finding that the programs used race in a sufficiently limited way to fulfill a compelling interest in diversity. After an 8-day trial in 2020, District Court Judge Loretta C. Diggs of the U.S. District Court of North Carolina ruled in favor of the school, making special mention of its history steeped in racism. The university continues to face challenges admitting underrepresented minorities, particularly African American males and Native American, said. Stepped in to consider the case, but it was heard by a federal court. There are many programs that will be impacted, but in the first U.S. Circuit Court of Appeals affirmed the district court did not clearly argue finding covered intentionally discriminated, and the admissions process of the school takes into consideration several components, including pre-application first. Cameron T., the lawyer, argued that Harvard case charged the school with ignoring precedent and mistreatment of Asian Americans. He said that its admission process penalizes them for supposedly lacking as much leadership, confidence, likability, or kindness as white applicants. In particular, attack Harvard's system based on so-called personal ratings by considering race alongside subjective criteria like self-confidence, likability, and courage. Investors invite admission officers to rely on anti-Asian stereotypes, Norris added. Harvard was supported both Harvard and the University of North Carolina by their lawyer, urging the justices to reject the invitation to ignore the court precedent stemming from the court's 1978 decision in Regents of the University of California v. Bakke, where the court held that the recognition of the nation's future depends on leaders trained through wide exposure to the ideas and mores of students as diverse as this nation of many peoples. That's sort of the slightly more detailed context of the decision, some of the issues, So we shall watch developments, but there's no doubt the current flurry of activities for this year and last year in overturning many of the decisions that appear to be handicap or reinstating some sort of uh, justice for minorities or trying to mitigate the disadvantages of race and racial injustice that spans centuries in America have yet again been overturned by a court that has been described as on rogue and dumb. We shall be watching developments as always. And there we shall leave it on this episode of The Diary of a Lawyer. Thanks for listening. Bye. Let's speak again.